Hear ye, hear ye, hear ye. All persons having anything to do before the Honorable, the Justices of the Appeals Court, now sitting at Boston, within and for the Commonwealth, draw near, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open. Please be seated.
Good morning. Welcome to the Appeals Court. A special welcome to our guests from Northeastern. I am Justice Meade. To my right is Justice D'Angelo, and to my left is Justice Tan. We'll be the panel for all of the cases we hear today. Each side gets 15 minutes. You needn't use all your time. We don't entertain rebuttal. We have read everything, so my best advice is to get right to the point. With that, I'll call our first case, 24P689, Commonwealth versus Marino. Mr. Corman.
Good morning, Your Honors. May it please the Court. My name is William Corman, and I represent the defendant in this particular matter. From the outset, I will state, after having reviewed the case and discussed it with my brother to some extent, this case really should stand for the proposition that in circumstances where the record is less than clear, trial counsel does need to be a little more direct in figuring out exactly what it is he's objecting to. While I'm certainly not conceding any facts, I am willing to concede that the record is murky, to say the least, in terms of exactly what was objected to and what wasn't. The pretrial motions leading up to the actual trial itself were, to say the least, chaotic and somewhat confusing. Regardless.
Counsel, it seems like I want to set the stage, as I think you're trying to do.
Your Honor.
Right from the beginning, would you agree that defense counsel conceded that the victim could say something to the effect of, I've been raped or sexually assaulted 70 times? That was really not objected to. Would you agree with that? I
would. I don't think I have a choice but to agree to that. I think it's abundantly clear from the record. And setting the stage, yes. So
I guess my follow-up question to that is, and what is the prejudice if that all was unobjected to? So
I think what I would respectfully ask the court to do is take a giant step backwards and look at this case sort of from above rather than at a line-by-line way to look at it. We have a history of horrific sexual and domestic violence between allegedly committed by the defendant upon the victim. We have multiple jurisdictions. We have witnesses coming in from other states to testify to it. What I would suggest is that the fact that this evidence came in, the fact that this evidence was almost stipulated to, as Justice D'Angelo stated, doesn't necessarily mean that each and every element of all those allegations should have come in. For example, while there was certainly testimony that trial counsel essentially stipulated to regarding these prior sexual assaults, that doesn't in and of itself allow every single thing that was subsequently proffered to come in. And so I would suggest that there is a way to differentiate between the abuse in Florida, the things that happened on that day, and the prior sexual assaults or the
Mr.
prior
Corman,
events as well.
Let me ask you
I'm sorry.
When they were litigating the motion in limine, trial counsel essentially agreed to the Florida conduct coming in and the history of abuse.
I think that those are two different issues. I think that
he said as long as there was a limiting instruction.
Correct. Correct.
So we're reviewing for a substantial risk of a miscarriage of justice.
I think we have to. Okay,
so you're agreeing that this was not preserved.
I think that it is murky enough that I would certainly tip my hat to the idea that we need to look at it from a substantial risk. And I think that looking at it from a substantial risk, we still have a problem here. I mean, again, what we end up having is 43 pages on direct testimony. In my rough math, which is notoriously poor, it's 35% of the alleged victim's testimony has to do with uncharged conduct in this particular case. And I think that when we look at the case law, we realize that sort of, again, we can't quantify it, but those sort of percentages are overwhelming. I mean, it's a third of the victim's testimony had to do with things for which the defendant was not on trial in that particular moment.
If they're admissible to show motive, intent, the hostile nature of the relationship, even though there's a great quantity of it, it's certainly individually was permissible to have it admitted into evidence.
Well, what I would suggest, Your Honor, is that at some point we need to start drawing a boundary. And that's what I'm asking the court to do in this particular case. At some point, the uncharged conduct overwhelms the charged conduct. And when do we draw that line? And I think this case is a perfect example of when we need to draw those lines.
How do we draw that line when we're reviewing for an abuse of discretion? I mean, if there had been something like, at trial, Judge, this is way too much coming in. This isn't what I foresaw during the motion in limine. Can we put a stop to it, or at least circumvent the rest of it? Then we could look at that, whether the judge made the right or wrong decision. But no one makes that type of objection.
I think that trial counsel, well, I don't know that I completely agree with the court. I think there are times where trial counsel objects and then doesn't state for the record why he does object.
He objects, and his objections were sustained, and he asked for the limiting instruction to be repeated, right?
And I think his asking for the limiting instruction is a sign that this court should assume was that he was intending, or I'm sorry, I think this court should take a look at his request for the limiting instruction as his intention to basically say to the court, we are adding so much to this case that need not be here. And again, one of the reasons I bring it up is that, and I know the state is going to mention this, is that the evidence in this case, there was a lot. There was a lot of evidence against Mr. Marino. There's no way around that. So in cases like this, where the government's case is strong, I would suggest these are the cases where this honorable court needs to be most cautious about protecting the defendant's rights in allowing this overwhelming amount of evidence to come in against the defendant.
Even if we ignored the prior bad act evidence, is it possible that this defendant could have been portrayed in a positive light to the jury?
If we ignored the prior bad act, can we indicate, I'm sorry, can you ask that one more time?
Is it possible to have portrayed this defendant positively in the eyes of the jury apart from the prior bad act evidence?
Well, I think that, that's a great
Tough
question.
to do with his statement.
Well, so I think it's a great question, but I think my response is this.
I worked hard on that one, thanks.
I'm sorry?
I worked hard on that one, thanks.
I appreciate that, Your Honor. I appreciate that. So I'm going to answer it not as directly as the court wants me to. And what I'm going to say is this.
Which we love that.
I know you do. I know you do. I know, for the gallery as well. What I would state, Your Honor, is this. There was so much prior bad act evidence that came in that defense counsel, I would suggest, needed to stop that bleeding at every possible opportunity. So had the prior bad act evidence not come in, I would suggest that the entire focus of the case would have been different. Therefore, perhaps it would have been possible for trial counsel to portray the defendant in a different light. I don't know that better is the word that I would choose, but certainly in a different light. I think it changes the landscape of the case if there's no prior bad act evidence.
Can we go back to Justice Tan's question regarding prejudice? I mean, the defendant's statement, I won't call it a confession, but it was pretty close. What do we do with that when we come to prejudice?
I think that we, and that's when I said we need to take a look at this case from sort of from an up-top perspective, sort of a macro versus micro way of looking at the case. And I think that in that circumstance, what we need to do is we need to recognize that there are cases where the overwhelming amount of evidence that comes in, the prejudicial evidence, the evidence that is prior bad act evidence, comes in and overwhelms the case, and therefore I think it's incumbent upon this court to protect defendants, especially in circumstances where the evidence against the defendants is very strong to begin with. In other words, the phrase I'm looking for is the government's gilding the lily here. There's enough evidence, or there's certainly a lot of evidence, as Justice Tan suggested, with the statement, again, not a confession, let's not go that far, but there's enough evidence here, so then don't we need to, in cases like this, exactly like this, be protective of the defendant's rights? In other words, the government did not need to do everything they did.
Here's my problem with that argument, which, by the way, I think is the only one you can make in this case.
I'm doing my best.
You're doing your best. What do you do when the judge is not even remotely asked to exclude the stuff? So are you saying that in a global sense, a judge is just sua sponte, supposed to say, there's just too much here, we need to put a halt to this? Because again, as my colleagues have said, not only was there no objection in the motions in limine to agree, he kind of just agreed to it all. So you think a judge has to step in there and say, despite what defense counsel might do, even if it's strategic, maybe, I've got to exclude it all?
I think that there are cases where that is absolutely the path that a judge needs to go down. And I recognize that it's a difficult one. I mean, who are we kidding? But again, this case I actually think is a perfect example because there's just so much evidence already against Mr. Marino in this case that to then fly in witnesses from the state of Florida to add to this case is overkill.
Yeah, you made an argument, I was going to ask you about that. And I was sort of going to ask your colleague as well, but what's the problem with that? Just because the incident happened in Florida and they brought Florida officers, what's the legal prohibition from doing that? They're witnesses. What's the problem?
Oh, I mean, I don't think there's generalized legal prohibition against doing it. But again, it's sort of my answer to Justice Tan. It's at what point does the court say, like you said, time out, enough is enough. We don't need to add all these other facts when the government's case is already so strong. And I do think that there are circumstances, I think this case is one of them, where a judge has the I may go so far as to say obligation to protect the defendant's rights.
That's tough, though. That's a tough, I mean, is it the judge's responsibility to protect their rights if their attorney isn't asking for it? I guess it's just sort of exactly what Justice D'Angelo is saying. What was a judge supposed to do? The government has a right to present the best case, and try the case in the way that they want. And of course, each side's going to, be zealous in terms of presenting their case to convince the jury, right?
Well, I'm sorry, I didn't mean to cut you off.
And I guess just a second question I have is that I understand your argument in terms of the overwhelming nature of the evidence and an already strong case, but in this case, the jury didn't really swallow whole cloth everything, right? The rendering of, it wasn't across the board guilties on everything, right? They did acquit the defendant of some charges, so they were discerning, right, and thoughtful in
So I'll address Your Honor's second point first.
Sure.
And it's a speech I've made before. I think it was the last time I was from Justice D'Angelo. I said this. I, as a trial attorney and an appellate attorney, I dislike the notion that because the jury acquitted on certain counts, therefore the jury either followed instructions or was discerning. I think there's 1,000,002 reasons why jurors do what jurors do. And I think to sit there and say, well, he was found guilty of something, therefore there's no prejudice, I think that's, and I'm not suggesting that Your Honor is approaching this.
We don't know why they did what they did. We never really did.
And I think that's putting a huge Band-Aid. I think that has the ability to put huge Band-Aids on gaps in lots of cases, to simply say, if there's 22 charges and individuals found not guilty of one, therefore the trial's fine. I think that's problematic from a legal standpoint. And I know that's not exactly what Your Honor is saying, but I think we need to be careful because there's an acquittal on something, therefore it's a fair trial. I think that's a challenging statement to make. So, and as far as Your Honor's first point, which I've now lost in translation, I think that the concern is this. There are, at some point, if we're drawing boundaries, at some point there's a question. How much does a trial need to tip unfairly towards a defendant before a judge has an obligation to step in? And I think there are circumstances where the court does have an obligation to do so. Admittedly, it's a slippery slope, and we certainly don't want judges to subsume the roles of either counsel in these cases. But I think there are circumstances where, as Justice Meade suggested a little while ago, perhaps things do get out of hand. No one quite expected the testimony to come in the way it did. Perhaps the judge in this particular case didn't think that nearly a third of the victim's testimony was going to have to do with stuff that happened out of state and wasn't directly relevant to the facts and circumstances of this case. And I think in those circumstances, a judge may have an obligation to step in, recognizing it's a slippery slope. But if we're drawing boundaries, I think this is a case, again, where the government's gilding the lily, and this is a case where a boundary needs to be set. If there are no further questions, I'll rest on my brief. Thank you very much.
And thank you. Mr. Rubin. Go ahead.
Good morning. Daniel Rubin, Assistant Attorney General for the Commonwealth. May it please the court. The defendant is challenging here two distinct sets of prior bad acts, as has been discussed already. There's the summary evidence of the history of the relationship between the defendant and the victim, and there's the more detailed evidence of what happened that day in Florida at the time when the victim finally, after years, reached out to law enforcement to try to seek help from law enforcement for her ongoing predicament.
Counsel, let me go right to that. That's what you said in your brief, and counsel in the motion in limine, the Commonwealth said that. The limiting instruction the judge gave, though, was for the ongoing relationship and claimed abuse and patterns of conduct. So that doesn't really match with what you argue in your brief and trial counsel said about why the Florida incident came in. So if the jury is supposed to be limited to the limiting instruction and counsel argues something different than why it comes in, what do we do with that?
Well, in this instance, I don't think that the wording of the limiting instruction went beyond what had been discussed and agreed and ordered. I think it actually was narrower than what had been discussed and agreed and ordered in the way that you've pointed out. The limiting instruction, you're correct, I don't think it does mention explaining the delayed disclosure. I think at that point,
this happens a lot, counsel, and that's why I bring it up, which is, and as a former trial judge, I was probably guilty of it as well, you sort of just read the 403 pattern of conduct, blah, 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 and you just go through and say those things, and that's what the jury's limited to. But the prosecutor doesn't argue that that's why it comes in. Comes in for a specific reason, which I think it should have come in with that. But now the jury is told you can only use it for X. So what do we do?
well,
Are we limited to that?
I don't think we are. There are cases where the limiting instruction has been imperfect and the convictions were still affirmed. Certainly there are cases where the limiting instruction was so general that that was among the factors that, that either this court or the SJC found that there was prejudicial error. But the limiting instructions are not always perfect. We're reviewing here either for prejudicial error or, as my brother I think appropriately concedes, for a substantial risk of a miscarriage of justice. I'm just not sure that leaving out one of the permissible purposes in the limiting instruction is enough to say that there was some fundamental flaw here. So there are, I apologize. Since we are discussing, it seems, under substantial risk of a miscarriage of justice, one of the factors, one of the prongs of that analysis is whether the decision by trial counsel here not to object or to allow in, or I'd argue in some circumstances to seek to have admitted some of this testimony, is whether that was a reasonable tactical decision. And here, though we can all see what the result was, I think it'd be hard to say that it wasn't. The idea in defense counsel's mind, the case that he was trying to put forward, is that the victim basically fabricated all of it, that everything she was saying was merely a ruse that she developed, a ploy that she came up with around June of 2021, the month of the Florida incident, to gain advantage in the family and property disputes between the victim and the defendant. And when that was the defense's case, and the defense counsel decided, I want to see everything that she's saying so that I can show how absurd it is, so that I can show the jury why it should not be believed. That's what defense counsel was trying to do, and I don't think that is an unreasonable way for defense counsel to have approached this case. Given that, I have trouble seeing a substantial risk of a miscarriage of justice. So given that the trial judge's decision on the relative weight of prejudice and probity was, I think, also even within his discretion, I don't know that I'd concede that we only win on substantial risk of a miscarriage of justice. I think the Commonwealth would be strong under prejudicial error as well. And even on whether the evidence was properly admitted at all, given what defense wanted it in for. Given that... Did
defense counsel articulate that?
Defense counsel did articulate that in some of the pretrial discussions. I think on June 5th.
He said it doesn't matter to us how much voluminous bad acts come in because we're just going to say she's lied about everything.
So on the transfer from June 5th, beginning at page 145 is, I think, the closest where that I could find in a transcribed hearing, where he discussed that at least for some of the Florida stuff, he wanted all of it in so that he could try to cross her on it and make her look unbelievable.
That goes directly to the claim he was making that the timing of that Florida incident sort of coincided with the civil lawsuit and so forth. So that kind of makes sense. But what about the sort of comment by the victim of she had been raped over 70 times? One was 70, one was 105, I think it was. How does that not just become so overly prejudicial that it should have been excluded? Because that didn't really go to the defense to a degree because the timing doesn't fit.
So the trial judge actually did address that in a sidebar in discussing, because there was a separate time where the Commonwealth sought to have similar testimony about the number of anal rapes. Mm-hmm. That question was answered, then the answer was stricken. And the judge a few pages later explained in sidebar that the reason that he allowed in the 70 vaginal rapes, I think the testimony was roughly 70, but not the roughly estimated 15 anal rapes, is because the defendant opened the door to that line of questioning during his opening and I think, though the judge stated it imprecisely, I think what the defendant opened the door to and what the Commonwealth was trying to accomplish with that line of questioning was discrepancies from one report to the next as to just how many rapes there were. That's what...
Can a lawyer open the door in an opening statement when that's not evidence? Should the judge have waited for the defense counsel to actually ask questions about it before saying it was opening the door?
Well, it's certainly not necessary where a strategy has been announced in an opening statement for the Commonwealth to wait for cross in order to rehabilitate a witness. And here, in seeking to have the victim explain where that estimate came from and why she had whatever level of confidence she had in it, I think that properly addresses what defense counsel stated in his opening, that he was going to be a subject of cross.
When they talked about the Florida conduct, defense counsel said he had no objection because it was charged conduct. if the trial was occurring in Florida, I would agree with him, but since this was Massachusetts, it was not charged conduct here, right?
It was not charged conduct here. I don't think that would have been proper as the sole basis for the admission of the Florida conduct. But I think defense counsel does, at other points, discuss in more detail that it's not just that it's charged conduct, it's that he thinks he's going to be able to cross her on it and make her look like she's fabricating everything. If there are no further questions, I'll ask this court to affirm the convictions. Thank you.
Seeing none, thank you. Thank you both. The next case is 25P551 Commonwealth versus VILLAR Navar. Mr. Hennessy.
Good morning. May it please the court. Kevin Hennessy on behalf of the Commonwealth. The motion judge's order suppressing cocaine, fentanyl, and cash should be reversed because over the course of what began as a stop for a traffic violation, the officer developed a reasonable suspicion based on facts that were articulated at the hearing that the two individuals in the motor vehicle were involved in drug activity, providing a constitutional justification for the officer asking the female passenger to exit the vehicle and justifying the subsequent brief questioning of the female passenger that turned this into a situation based on her statements where he had probable cause to believe that the defendant had just sold her drugs, justifying the arrest. With respect to the facts that were developed over the course of the hearing that provided the officer with that basis for a reasonable suspicion, I'd like to focus on what the Commonwealth cites in its brief as the fifth fact, which was discounted by the motion judge in his findings. I believe in the judge's oral findings, there's maybe only 7 or 8 lines that are dedicated to analyzing the officer's belief that the female passenger and the defendant were lying regarding their relationship with one another, and that the female passenger specifically was lying regarding her decision, regarding her ability to communicate with the defendant in Spanish. The body-worn camera footage, which captures the entirety of this interaction, was submitted to evidence, and this court, as its documentary evidence, can review the body-worn camera footage de novo with no deference to the trial judge.
Can I ask you about that? And I have sort of a follow-up question.
Yes, Your Honor.
Even though it's body cam, the judge made a credibility determination of what he saw on the body cam. Do you think, even though we review the body cam, that we can change or be different about a credibility determination than the judge?
Based on the Trombley case and some of the cases that discuss documentary evidence or recording, which is what body-worn camera footage is, I would submit that Your Honor's...
Those cases say that we can see what the judge saw, and therefore we can make a determination that it's different. But this is a credibility determination. He specifically says, I do not find that they were lying based on what I saw on the body cam. You're asking us to say exactly the reverse. Based on what we saw on the body cam, we do think they were lying. You think we have that authority?
Yes, Your Honor, particularly where these witnesses were not testifying witnesses. So I would submit that Your Honors are in just as good of a position to assess Ms. Mara and the defendant's credibility based on the statements that they made as the...
Any case that says that? That says specifically as to credibility, not that we can see something different than the judge did, like a throwing of something that we can see, we can make that determination.
I don't have a specific case, Your Honor, but I would suggest that case law stands for the proposition, particularly where this wasn't a determination that the judge was making with respect to a testifying witness that's captured on the body-worn camera footage, because I think that would be a much different position where this court would have to give some deference to the trial judge's determinations based on the witness's testimony in court. But I would submit that here, Your Honors are in just as good a position as the judge to assess the credibility of Ms. Mara and the defendant. And I would submit that Officer Morill's, the inference that he drew that they were lying regarding their relationship and their ability to communicate is borne out by the body-worn camera footage. Over the course of the entire 10-minute or so interaction, the defendant is unable to say really anything in English. He says Lane in response to one question. He might say okay at a couple of other points.
Well, he understands, right? Doesn't the body camera video show that once, after the first interaction with the officer, and he gets the initial information, and he walks back to his car to check out, to run their information, he says, oh, wait, to the defendant, make sure you put it into park, right? And the defendant says yes, and does in fact comply. So there is some evidence of comprehension of English, right? And I think, I guess I'm just, I want to ask you about, so the fact that, I think the officer says that he believes they're lying because the passenger, her Spanish skills aren't as good in his opinion, right? In the officer's opinion as he thinks they should be, I guess. Whenever he asks her initially, do you speak Spanish? She says yes. And then he says, well, talk to him and get him, like, where does he live? What's his address? And she says, I believe, donde está en su casa, right? Which the officer, based on he had, I think, what was it, 3 days of Spanish for drug investigations. And he said, I believe he had 2 years of high school Spanish as well, that to him was not correct. Was not a correct interpretation of what's his address, correct?
Yes, Your Honor. And just to get back to the first point that the court made regarding the officer's belief regarding the defendant's comprehension of the officer's command, on the actual body-worn camera footage, at that point when the officer is telling the defendant to put the vehicle in park, which I grant you, the defendant does then put the vehicle in park, the officer's also gesturing as if he's moving a gear shift and he's putting his hand up saying stop, stop. So that could be interpreted two ways, where the officer is also demonstrating physically what he wanted the defendant to do. So I'd submit that doesn't necessarily, it's not as probative of the defendant's knowledge of English as the defendant would like the court to think. And it's crucial to view this fact in conjunction with all of the other evidence that Officer Morrill had developed over the course of this investigation.
Can I ask you about your fifth point of what you say established reasonable suspicion, and that's the meaningless ride, the tripping the block, as the officer testified to. And you're saying that we can consider that, even though the motion judge found that did not occur.
And Your Honor, I think candidly, out of all the points that the Commonwealth cites in support of reasonable suspicion, that is the weakest point, because as the court can see from the map.
But I guess my question is, it's similar to Justice D'Angelo's question about the other matter. Don't we have a Jones-Parnell problem with that? We can add facts to the record that don't, as long as they don't contradict what the judge has found. He found that there was no meaningless ride, that they were going to a cafe, and that they didn't even go around the block. Now, I understand that they probably didn't do that because they saw the marked police cruiser and ended the meaningless ride, right? But, I mean, that was an argument for the motion judge.
I would agree with the court, and I would, as opposed to the situation that Justice D'Angelo discussed regarding the credibility determinations of the witnesses in the body cam, I think that this is a different situation where the judge did make findings. But going on into some of the other factors that...
So just to be clear, then we cannot consider the meaningless ride.
I would submit that the court can consider the officer's opinion that he suspected, at least, that they were going to continue looping the block, but for the fact that the officer.
But the judge found, as a matter, as a matter of fact, that that did not occur.
My understanding of the judge's ruling was that he found that what occurred was not a typical meaningless ride around the block because it wasn't completed in their path of travel was logical with going to.
And for us to say otherwise would contradict that finding.
I would submit that the court could take the officer's testimony that he at least suspected that they were.
I don't want to waste too much of your time. I have a different question altogether. Was the defendant charged with the drugs in her boot, in Mara's boot?
He was. He was charged with 2 counts of distribution, one for the fentanyl of Class A, one for distribution of the cocaine, Class B. But getting back to the totality of circumstances that was confronting the officer, he sees a female coming from the vicinity of 22 Ashland Avenue, a residence that the police department in the preceding month had received 4 to 5 complaints for drug activity. Calls for service was what the testimony was. The court can infer from that that there were civilians contacting the police department regarding drug activity going on at that residence. There's approximately 1 per week in the month leading up to this incident. Miss Mara, when speaking with her during the course of the traffic stop, the officer confirms that she's living at that address that's actively the subject of drug complaints. The officer also learns, in looking at her board of probation record, that she has a history, granted it's a little bit of a dated history, of convictions for drug possession, but that dovetails with the information he had regarding this address. The officer describes the deer in the headlights, the startled look that both the female passenger and the defendant make in the direction of his cruiser as they're approaching his cruiser. And then we get to the fact that based on Officer Murillo's interactions with these 2 individuals, it appears clear to him, and I'd submit it was reasonable for him to infer, that they didn't actually know each other, and they were lying about their relationship. And all of that other information, when we're talking about just a reasonable suspicion, we're not at preponderance of the evidence, more likely than not. We're not at probable cause. This is a low bar. And Officer Murillo was an experienced investigator. He had done a significant amount of drug investigations. And I would submit that at the end of his interaction, he had formed a reasonable suspicion that there was drug activity afoot and was justified in taking the proportionate response of just getting Miss Mara out of the car.
I'm sorry to interrupt. Did either of them have a valid driver's license?
Neither of them did have a valid driver's license.
So the judge found the stop was unnecessarily prolonged, right?
Yes, in part.
The fact that neither of them had a driver's license, wouldn't that be a justification for holding them there?
Yes, Your Honor. And I would distinguish this case. Counsel submits that the Cordero case is controlling, and I would submit that this case is completely distinguishable from Cordero due to the duration of the stop. The time from the stop at 5:02 to the time that he develops probable cause to arrest the defendant at 5:12 p.m., it's 10 minutes. In Cordero, we have a 40 to 45 minute waiting period when other officers are getting on scene. This officer quickly got to the point, and I know
after she's out of the car, what she says obviously gives the officer probable cause. But what justifies getting her out of the car?
The fact that I would submit that at the moment she was asked to get out of the car, he reasonably suspected there was drug activity afoot, which provided him with a constitutional justification for asking her to exit.
So not a safety concern.
I don't believe that there was any testimony that the officer had any safety concerns. And with respect to the point Your Honor made regarding the license status, that's another crucial fact to consider that I think distinguishes this case from the Soriano-Lara case, in which, in that case, the trooper went off into general investigative questions regarding the comings and goings of the individuals for some period of time. In this case, once the defendant produced a Dominican Republic license, as the officer testified, he was trying to determine whether the defendant was a resident of Massachusetts who needed a Massachusetts driver's license, or in fact
And
could have.
he did, right? Because the defendant pulled up the address on his phone, he determined he lived in Lynn, and at that point, the officer also knew that the passenger didn't have a valid driver's license. So at that point, he knew both of those things, correct? And so I guess what would you say, because I suspect that the defense attorney may stand up and say, well, that was an unconstitutional prolonging of the stop after that, right? So how would you respond to that?
I would respond, Your Honor, that he didn't confirm the defendant's actual address in Lynn and zip code until approximately 5:10, which is 10 minutes into the interaction and only a minute and 30 seconds or so before he had Miss Mara get out of the car and had the conversation with her. And the Soriano-Lara case makes clear that, a brief detour from questioning regarding the purposes for the stop doesn't necessarily require suppression. And I would submit that that was all that this was. And I'd also contend that
Has the Commonwealth waived any argument other than there was reasonable suspicion to get Mara out of the car? Is that the only argument you can make on appeal?
Yes, Your Honor, that is the only argument that the Commonwealth has advanced in its brief. But I would close by saying Officer Murrill wasn't required to bury his head in the sand and ignore his common sense in terms of his interpreting the facts as they came at him. In the touchstone of Article 14 is reasonableness, and I would submit that his conduct that day was reasonable. So for all those reasons, I would ask that the court reverse the motion judge's order suppressing the evidence in this case. Thank you.
Mr. Zandrowski.
Seeing no further questions, rest on my brief.
Time's up.
Thank you.
Good morning. May it please the court, Matthew Zandrowski on behalf of Angel Villar Navar. Basically, I've raised two issues on appeal. I think I'll start with the first one, whether there was reasonable suspicion to issue that exit order and essentially seize the passenger.
Why do they need reasonable suspicion? Neither the driver nor the passenger could drive that car away. What were the police supposed to do? Just leave them there on the side of the road in the car?
Well, just leave the car there, I think.
Okay, but what about the two people? Because you're saying they couldn't ask Mara to get out. Could they have asked the defendant to get out?
Well, I think there's asking them to get out, and then there's also this issue of I think what the trial judge had found was, issuing commands to the extent of come here. And so even if this is sort of a voluntary, do you want to get out of the car because you know.
So again, my question is, when the police determine the driver can't drive the car away, the passenger can't drive the car away, at that point the police should just leave. They should leave these people in the car, right? I mean, under your argument, is that right?
I would think so, as long as he's not operating the vehicle, kind of,
Kind of risky, isn't it? You're kind of going on the word of the defendant, hey, you don't have a license, don't drive that car away, but here are the keys. That's what the police should do.
Well, I think the police maybe could ask them out, but certainly not say, hey, come here and start issuing commands like, hey, you can't stay in the car perhaps, but that's not exactly what happened. So, and certainly it didn't seem like that was his aim at asking Ms. Mara out of the car, because he had, immediately went into a whole spiel about, I know what you guys have done.
All right, so as a follow-up to my question, I guess they could have left them in the car or asked politely for them to get out of the car. Can your client challenge ordering Mara out of the car at that point? And how? Because we just said it's no longer really a traffic stop.
Right.
The traffic stop's over from your best argument, which is stay in the car, you can't drive. So why can't they say, hey, you, passenger, get out? How does your client have the right to contest that? Because it's not prolonging the stop.
If we grant that the stop was completed at the time they issued the exit order, which I don't know exactly has happened here without tickets and things like that, it's sort of, I think, a gray area. But if we do assume that,
don't you want to assume that? because if it's not over, then it's not prolonged.
Right.
So let's go from your best case to say the stop is completed. Can your client argue that pulling the passenger out is, I don't want to say unconstitutional, but I guess I can, to your client? How does your client have the right to argue that?
I think that given it's a traffic stop and whatever's happening is as a result of this traffic stop is sort of where the standing comes from, and that it's hard to separate any kind of asking politely or if the traffic stop's over from the actual reason behind the stop. So it's sort of essentially still occurring to some extent.
Well, I asked Mr. Hennessy, and he accepted with great alacrity the idea that neither of them have driver's licenses. So, and the judge allowed the motion to suppress because he said the police officers unlawfully prolonged the stop. There wasn't going to be a go. No one could lawfully drive the car.
Right.
So how does that prolong the stop? They weren't going anywhere.
How does, in your question, what is prolonging
He
the
couldn't
stop?
drive, well, he said they prolonged the stop, but they couldn't drive away. The judges, once they had the proper information, he should have let them go. But they couldn't let them go. They didn't have driver's licenses.
I don't see why they couldn't have let them go and,
Well, then they could have let them go, but then they'd be part and parcel to unlawful operation of, unlicensed operation of a motor vehicle,
right.
which is unlawful.
Okay.
So you're right, they could let them go, but that would be wrong.
I'm not sure I'm following your question.
I'm not sure what I'm not saying. They don't have driver's licenses,
Yes.
and people without driver's license aren't allowed to drive.
Yes.
So how they weren't going to let them go. They couldn't.
They couldn't let them drive away in the car, but I think like he alluded to Miss Mara, that, she would be able to just walk home.
The judge said once they found out the correct information to write the citation, and for her for the seatbelt violation, that should have been the end of the stop. But they couldn't go anywhere.
They certainly couldn't drive away, right?
They could not drive away. Yeah, that's what I would grant
So I
that.
guess this is a follow-up to my question is, so what are the police supposed to do? Say to them, hey, walk away, call for a tow truck? What are the police supposed to do?
I think in this case, yeah, the car was parked on a public street. It wasn't impeding traffic. They could have just left the car there.
So
And
there
these
was a
people-
tow policy, right? The Methuen tow policy was entered into evidence as Exhibit 4. We don't have it. That wasn't provided to us. And there was actually not any testimony, correct, about the specifics of what the tow policy was at the hearing. Am I correct about that?
I believe at the hearing, the officer testified that he sort of had discretion to tow the car in this situation or not. So it was an exercise. It would be an exercise of his discretion, according to that policy.
Right. And there was testimony that the car, from the officer, that it was parked on the street, pulled over on the side, and it was not impeding traffic in any way, correct?
Correct, yes. So yeah, I think that essentially perfectly fine to leave the car at where it was, and these people could have walked home, especially when she lived so close. And so to add to that, the remainder of what Officer Morell had observed did nothing to provide reasonable suspicion. He didn't observe anything approaching a transaction. He didn't particularly...
Well, Mara lives at the address 22 Ashland Avenue, where there's been drug activity, right? And they also know that she has a history of drug possession.
Right. Well, there was suspected drug activity at 22 Ashland, and so it's sort of left a little bit ambiguous in the testimony as to what that even means, who is suspecting this drug activity, if there even actually was drug activity.
Well, what's important is that the officer is aware of it and reasonably articulates that as one of the bases for his suspicion, that they didn't know what exactly happened. I mean, it's not a search warrant affidavit, right?
Right. Well, but I think it goes to the strength of that evidence of suspected drug activity is weaker than drug activity. And I think that, in fact, Ms. Mara did live at that address, and that was her address, and that people have that right to work and live in high crime areas or a multifamily house that perhaps has some people complaining about drugs in it. And so without anything else, it's not really specifically tied to her or the
Well, I
Subaru
mean,
that
she
pulls up.
has a history of drug activity herself, and she's living in a house that there's drug activity. The police
Right.
officers see this suspicious thing, that when they see them in the car together, they're startled that they've seen a police officer. Deer in the headlights, I think he said.
Right. Well, I think that essentially it isn't really anything specific that there is a drug transaction occurring at this particular moment in time. She has a history, yes, but that doesn't mean that this is a drug deal, and there's really no reasonable suspicion that what is occurring right now, on that Friday night at 5 p.m. was a drug deal or any kind of drug transaction. Same thing, they were startled by the police officers. They didn't make any evasive driving, they didn't speed away, there wasn't any.
He believed that he was being misled. Is he entitled to investigate that?
I mean, sure, he can investigate anything he wants, but I don't know that even from that little exhibit and the turns that they made, that we can determine that he was being misled. And I think it also sort of goes into a little bit of a
Well,
catch-22.
let me ask it differently. If they were lying to him, would that be something that would add to reasonable suspicion?
If they were lying, or if he knew they were lying to him, sure, that would add to reasonable suspicion.
She knew defendant because she's friends with his father,
Yeah.
whose name she did not know.
No, she did know his father's name, who was Jonathan. So she knew their father's name was Jonathan. And so there's really nothing in the record or anything to disprove that she was friends with this guy's father whose name was Jonathan. I think on the face, that's not particularly suspicious, and there's really no reason to believe that she is lying about this from anything that officer could
I
have
also
known.
thought that she was being dishonest about her ability to speak Spanish.
Sure. I think it sort of goes to this question of what does it mean to speak another language. I did notice when I was reviewing this that the DA at that hearing asked the officer, "Do you speak Spanish?" And he said, I do not fluently speak Spanish. And so I would suggest there's degrees of being able to speak a language, and that Ms. Mara in this situation really didn't hesitate in the Spanish he used. It seemed to be fairly basic Spanish.
But if he believed, or reasonably believed, that she was misleading him about her ability to speak Spanish, is that something that could be considered in the reasonable suspicion calculus?
If he reasonably believed that, but I don't think on this record.
He asked her to ask him in Spanish if he had a United States driver's license, and she said, United States driver's license, which is not Spanish.
Right. I think this goes to, this is a traffic stop. This is a specialized, police.
My question relates to whether he reasonably could believe that she was lying to him.
Then I would say no, he could not on this fact reasonably believe that she was lying to him.
Even though she asked in English after being asked to ask in Spanish.
I would think so, yes, because so she's not proficient, she's not fluent, and she doesn't know how to conduct a traffic stop in Spanish. Does not mean that she doesn't speak Spanish. And so we cannot determine that she was lying about speaking Spanish because she's
Perhaps I
unable
misunderstood, but I thought the officer asked her, can you ask him in Spanish if he has a United States driver's license? And she said yes, and then she asked in English. That seems suspicious to me.
I don't know that he specifically asked her any of these sort of specific direct questions. Can you translate this? I would also suggest that even the act of doing that is sort of prolonging this stop, fishing for information that she perhaps doesn't speak Spanish, and trying to throw it off when he's got a brake
During any
light.
traffic stop, can't the police ask for a license?
Sure, but that's different than asking a passenger to translate a phrase in a traffic stop that he's taken a course for, a specialized course for conducting a traffic stop, and he is completely...
Well, I think other than the defendant, we can all agree that no one was proficient in Spanish.
I think the officer is more proficient than he let on, but yeah, people have varying degrees of ability to speak Spanish. But the officer certainly recovers some ability to speak Spanish after the defendant's been placed under arrest. And so, and he's demonstrating a lot of ability to speak Spanish when he's saying, hey, Ms. Mara, what's the name for street? This is easy. And that doesn't have anything to do with the traffic stop anymore. This is just testing her ability to speak Spanish. And this is in the process of a traffic stop in the first place, a nervous kind of environment. I don't think it's fair to judge a passenger's ability to speak Spanish in this situation. I don't think it's reasonable. I don't think we can reasonably say that she doesn't speak Spanish from here. I don't think that's reasonable on behalf of Officer Morrell. If there are no further questions, I'm happy to rest on my brief.
Yeah. No. Thank you. Thank you, Paul. Our next case is 25P 1082, Commonwealth versus Beechman. Mr. Lynn.
Good morning, Your Honors. Please the court, Paul Lynn for the Commonwealth. With me is Assistant District Attorney Gregory Galzio, who is the prosecutor in the motion hearing. In Commonwealth versus Horton, which the Commonwealth relies on in its brief, footnote 4, this is a Boston case in which the driver was not under arrest at the time of the impoundment. The court says impoundment of uninsured, unregistered vehicles with attached plates is typically proper. That is reiterated in Commonwealth versus Niccolo, which the Commonwealth also cites in its brief, in which the court cites one of the at least four justifications for impoundment of a motor vehicle, quote, where the vehicle stopped did not possess valid registration plates. So the police here.
Where does it say that in the policy?
It does not, but there is no case which holds that the written policy regarding inventory searches has to include a written section about the justifications for impoundment. And I found this in Commonwealth versus Leck, L-E-K, 99 Mass Appeals Court, 199 at 218, a 2021 case from this court, in which the court says, and I quote, with respect to motor vehicles, the standard written procedures we have required for inventory searches focus solely on the conduct of the search of the motor vehicle, not on whether the motor vehicle should be impounded and made the subject of an inventory search. So there are two different factors involved. One is whether the impoundment is justified, which is not governed by the written policy, and the second is whether the search was conducted pursuant to the written policy.
If it's not in the policy, could we not infer that it's then discretionary on the police officer's part about whether to impound or not?
Well, that was not what the officers testified to, and that has not been the general rule in this Commonwealth. The general rule has been, and again, as I say, that's Horton, that's Niccolo, another case is Commonwealth versus Eddington, 459 Mass 102 at 108, have all cited the situation in which the car is unregistered, unable to be driven on a public road as automatic grounds for impoundment.
You just said something that strikes me. On a public road, what about a situation where, like this car, it's not on a public road, it's in a private place, it's in a gas station? Then what?
Well, it's simply where he's pulled over. It's the business the business is closed, it's 1 o'clock in the morning, gas station isn't open. It's just where he happened to pull over. He can't move the car from that point. He can't just drive away.
He can't drive it away.
Yes, he can't drive it away, correct.
But presumably, he could, or the owner could call a tow truck and say, come and get the car from this gas station. It's not like on a public street where the police say you can't leave it here, we have to get rid of it. This is a different situation, isn't it? Maybe.
Yeah, I don't know of any case which distinguishes simply where the person pulls over. The fact is or that says that where a car has to be towed, which in this case it absolutely has to be towed, it matters who does the towing.
So the cases that you cited are all specifically public way, correct? Is that what you?
I'm honestly not certain as to whether they were all. I mean, they all cited the fact that the car was unregistered. I don't think any of them really specified whether or not how important the public way. Obviously,
Well, they do talk, like in Daly, they talk about it in terms of public safety with a car parked on the side of the road.
right.
So it is a consideration, right?
It's a consideration, but not one that affects the justification of the impoundment. There has to be a reasonable alternative here, and in the reasonable alternatives are usually ones where someone else can immediately take control of the car. For example, Gonsalves Mendez, where the passenger is a licensed driver. The car is, there's no evidence that the car has anything wrong with it. She can simply get in the car and drive it away. Here, there's going to be a delay. There's going to be a period where the car is unattended. And the police, in Ellerby, the court held that the reasonable alternative standard does not require the police to guard the car while the provisions are being made, while a licensed driver can be, while the defendant can call another tow company.
Why would the police have had to have guarded? Why couldn't the defendant or the or the passenger have stayed by the car until it was towed when it's in the gas station?
Well, again,
I agree, the police have absolutely no obligation to stay with the car, but one of
Right.
the cases talks about, is there a practical alternative to
Correct,
the tow?
correct.
So isn't it a very practical alternative in this situation for them to say, you can't drive the car away, call a tow truck, you guys stay by the car until the tow truck comes by? What's impractical about that?
It's not so much, it's a tough question because it's.
Like Justice Meade, I thought about that one all morning as well, so.
Sorry. No, the case law has not come out and said that you have to come up with an alternative. The defendant here, he doesn't ask for it. There's no case law that says that the police have to speculate about what policies, what they could do. And the police here testified that they were under the impression that they had to impound this car under these circumstances where it was unregistered. And
So what provision under the inventory policy was the car searched then?
Section 302 talks about where the car must be secured as where there's been an accident, and certainly here where the car is unregistered. And it says in paragraph 7, I believe, all motor vehicles secured by the Boston Police Department shall be inventoried.
So this is the supplement to the inventory policy, right?
Correct, yes.
Your sister makes, and understandably so, a lot about Section 103, Section 31 requires that the defendant be under arrest.
That is simply not the case. It says when in cases where the defendant is arrested, and then goes on to list things, but it doesn't say only in cases, and that's evident in the supplementary policy where they say this can also occur in situations where the car simply needs to be secured. Certainly in Horton, the driver was not under arrest, and again, that's a Boston case. And in Daly, the court held whether the defendant was under arrest was irrelevant to the propriety of impoundment where the vehicle was uninsured and unregistered.
Does it matter if in Daly that it was also uninsured and had attached plates?
No, the bottom line is that the defendant cannot drive the car.
It has to be towed.
It had to be towed by somebody. And the police were justified in saying that they were in as good a position as the defendant to do that.
Does it matter that they didn't mention Springfield's inventory policy in Daly?
It doesn't, I think, again, for the reasons stated in LEC. There doesn't have to be a written policy justifying the impoundment. There just has to be a written policy regarding the search, and here there was. The defendant didn't raise, but I would say that there's no merit to the judge's finding or ruling in this case that this was an extended traffic stop. The officers testified that this was an inventory search. The only thing that attracted their attention to this car was the fact that it had an expired license. So there was no evidence in this case that the police were conducting a traffic stop at the time that they were conducting an extended traffic stop at the time they began searching the car.
Does it matter that I'm forgetting the officer's name. He said his shift commander told him that you have to tow all unregistered cars.
I don't think that affects the decision one way or the other. I mean, it's, as the judge found, it doesn't necessarily matter that this officer told people that that's what you had to do. We have to follow.
It's not
the law.
subjective.
It's an objective standard. But here, every case in which that I could find in which there has been an unregistered car, the court has upheld, has ruled that the impoundment was justified. Are there any further questions?
Seeing none.
Thank you, Your Honor.
Thank you. Ms. Jacobson.
Good morning. Excuse me. May it please the court, Haley Jacobson on behalf of Lorenzo Beechman. I want to pick up where the Commonwealth left off with, or was speaking about Commonwealth versus Daly. And I just want to distinguish why Daly is not controlling here, nor any of the cases that have cited that, which have not held, or the parts of the cases, the other cases the Commonwealth cites, they're not really about individuals who have an unregistered car. But Daly is not controlling here for any number of reasons. First, as I believe the court pointed out, it was a case where the car was on the street and it was causing a safety hazard. Here, that's not the case. It's on private property. It's not in the way of any.
Isn't the parking lot of a gas station a place where the public would have access to?
Yes, it is a place where the public has access. Excuse me, but that does not define, or that does not change the fact that the car is permitted to be on private property when it's not registered. So it's not actually in a place where it is unlawfully, or where it is not lawfully allowed to be. And so the reasonable alternative here, which was perhaps not present in Daly because it was, the car there was blocking traffic, was causing a safety hazard, is that Mr. Beechman easily could have had the car towed himself. And also in Daly, though that case and Horton predate Oliveira, Gonzalez-Mendez, Abdallah, which all state that the police officers have to consider reasonable practical alternatives when they are readily apparent. They cannot ignore those alternatives. They cannot just jump straight to impoundment. Here, the police officers did not consider at all any other alternatives. The police officer testified and the judge credited that the officer immediately knew he was going to impound the car. He did not even ask Mr. Beechman if he could tow the car himself. And in fact, the officers never even told Mr. Beechman about the towing, so he wouldn't have even had an opportunity to offer that as an alternative. And if he had offered that as an alternative, of course, under Oliveira, that would have been a lawful practical alternative that the officers would have had to take advantage of. And so here, there's the judge's decision that there was a lawful practical alternative that the police ignored was absolutely correct.
He said that he could have had it towed to a private driveway.
Sorry?
Did the judge say he could have it towed to a private driveway?
I don't recall if the judge found exactly that he could have it towed to the private driveway, but that is what Mr. BEECHMAN testified, and the judge appeared to credit the fact that he could have had it towed himself.
Where's this driveway?
Mr. BEECHMAN testified that it was in part of an apartment building, or a parking lot of an apartment building that he managed, and that he had a parking spot available there that he could tow the car to. And the judge's finding that Mr. BEECHMAN could in fact have the car towed himself suggests that he credited that testimony. Now, there's the separate question of whether the policy permitted the officers to impound the car here, and the motion judge found that it did not, which was correct. And the Commonwealth is incorrect that Article 14 does not require that. The policy define when the officers can impound the car and that they follow that policy. In Commonwealth versus Campbell, the SJC said very clearly, the decision to impound a vehicle also must be made in accordance with standard written police operating procedures in order to comply with Article 14. That's a very clear statement from the SJC. Here, the policy did not permit the officers to impound the car when the driver was not arrested. And that alone is reason to suppress the evidence here, because that failure to follow the policy or to act in accordance with a written policy violated Article 14. Now, if the court is inclined for whatever reason to reverse the motion judge, of course there was the issue of pretext here, which the motion judge did not address, and which Mr. BEECHMAN is entitled to a ruling and findings on that issue. So if the court were inclined to reverse, I would ask the court to remand for a particular findings and rulings on that.
The officers say that he always intended to impound it.
He did say that,
From the
yes.
get-go. So how do we get to pretext from that?
Well, this court doesn't need to reach the question of pretext, because that was an issue for the motion judge to make particular findings and rulings on in the first instance. He has not made the necessary findings for this court to reach the question one way or another. And so it would be for the motion judge to do first before it could come to this court. And certainly his findings, the findings that he did make about the fact that the officers immediately began investigating were not.
Well, I mean, you say that, and the judge says that, but they shine their flashlights in the back seat. Is that the investigation you're talking about?
So the judge makes a finding, a factual finding that the officers were immediately began investigating. I think that's based on the fact Your Honor just cited. It's also based on the fact that they do an illegal pat frisk of Mr. BEECHMAN.
When they pull a car over at night, don't you think it's a good idea to see in the dark whether anything's in that back seat?
That may or may not be the case. Either way, that's not a finding that this court has to deal with in this case, because
I just don't understand how that's an investigation as opposed to an obvious safety precaution.
Well, it's not the only thing that the judge relied on in making this finding that it was an investigation. But again, that's really not before this court at this point. What's before this court is the issue of whether the towing was reasonably necessary, which it was not, because there was a lawful practical alternative that was readily apparent, and because the towing was not permitted by the Boston police policy, and they were required to follow their own policy under Article 14. And for those reasons, if the court has no further questions, I would ask that the motion judge's order be affirmed.
Thank you. Thank you both. Take it under advisement. We're going to take a short break now. Our next case is 25P549, Franklin Regional Retirement Board versus the Contributory Retirement Board Appeals Board. Mr. Sacco.
Thank you, Justice Meade. Good morning, Your Honors. May it please the Court. Michael Sacco on behalf of the Franklin Regional Retirement Board, or the Board as I'll refer to it in my argument. The Board alleges 3 errors in this case, Your Honors. The Crabb decision in what we refer to as Pellen 1, the remand, which was improper in this case, which interlocutory appeal, so we could not take a review of that case until now. The second error is the Superior Court's remand in June of 23, when it had before it a proper Crabb decision which found that, or a half-proper, I should say, Crabb decision in which it found that Mr. Pellen's back injury was not the result of a back impairment, was not the result of the September 25, 2006 injury. And the third error is Crabb's reversal of itself in the 2024 decision, where it did not explain how it went from finding that the evidence was insufficient to support causation to now all of a sudden saying the evidence was sufficient. So the background of this case, very quickly, I know Your Honors have read the papers. Mr. Pellen suffered an injury, as I said, September 25th of 2006 to his lower back. He filed for an accidental disability. As a result, a 3-member medical panel was convened to evaluate him. That medical panel had before it all the medical evidence that was submitted in the case, which was both in favor of Mr. Pellen as well as against Mr. Pellen, in the sense that there were other independent physicians who had examined Mr. Pellen and concluded that he was either not disabled or his disability was not related to this injury. There were suggestions of symptom magnification. There were diagnostic studies that were undertaken that did not show any acute injuries such as a herniation.
Can I just interrupt
Please.
and say that, so didn't the first medical panel, and I just want to make sure I get this right, because this case has had a, is it fair to say, a tortured history of
Yes, you may
almost
say
20
that.
years of litigation and multiple remands and reversals and all of that, right? So didn't the first medical panel, and I think that your opposing counsel argues, did not have the orthopedic surgeon's findings, right? And he evaluated the decedent pretty close in time to the injury, back, I believe, and correct me if I'm wrong, May 1st of 2008, and found that the thoracic cyst, right, was traumatic and directly caused, was causally related to the work injury. And that was never part of the record that the first medical panel reviewed.
Well, that's the allegation, Justice Tan, but I would
Right. And
point
so
out.
what is your response to that?
So my response to that
Because
is.
you just said they reviewed all of the.
Sure, and it's a fair question. My response is twofold. First, I would draw the Court's attention to page 312 of Volume 1, which is the so-called transmittal form. That
Sorry,
transmittal.
volume 1, page.
Volume 1, page 312. That's the transmittal form. That's what is sent to the medical panel. The transmittal form is 2 pages. The first page says that it includes the application documents. The application documents include the physician statement. What my brother's referring to is Dr. Corsetti's physician statement, which is not identified on page 2, but it wouldn't be identified on page 2. Only those other medical records are identified on page 2. At the Dalla hearing, the magistrate said that it was possible that Dr. Corsetti's opinion hadn't gone to the panel, but that it wasn't really relevant, or it wasn't a pertinent fact. And the reason for that is what was clearly in the record was Dr. McKay's opinion, who also, she was the surgeon who actually performed the surgery. She also opined that the cyst was traumatic in nature. But there were other doctors who had said that the cyst was not traumatic, it was incidental. So, in that realm, the Dalla magistrate looked at all that evidence, looked at the medical panel who said that Mr. Pellen was not disabled due to the back injury and that he did have pain because of the cyst, but because the cyst was incidental, they answered no to causation. So the Dalla magistrate laid all that out in her findings, which is a 20-page decision, very detailed, and denied the application. Well, we had denied the application at the board level. She denied it on appeal. We then go to CRAB. What CRAB does is it relies on 3 articles that were not in the record, and as this court's held in the Hollop case, which I know very well because it was my case, you can't refer to outside evidence that was not in the record, and the reference to that outside evidence was this evidence that a thoracic cyst or arachnoid cyst can be either traumatic or incidental, and her criticism of the panel was that the panel didn't say why it wasn't job-related. My response to that, Your Honor, is, or Your Honors, is something's either incidental or it's traumatic. I'm not sure how better you explain it. There were opinions in the record alleging both. Neither explain themselves because either something is incidental, it's a congenital defect, or it's the result of trauma. It's certainly reasonable that physicians would disagree on that. So the remand, which we believe was improper because it relied on those other extra record articles, was not proper. We couldn't appeal that decision. What CRAB didn't find in that case was there was anything wrong with their opinion on the lower back injury.
Can I ask you about the remand?
Sure.
What authority do you have that CRAB doesn't have the authority to remand basically for any reason? They didn't direct what the decision should be. They remanded it for further consideration. What's improper about that?
Well, what we believe is improper on that is that there was an articulation in the record for the arachnoid cyst, whether it was incidental or traumatic. There was no reason to remand it back. I realize they have the discretion to do it. I don't dispute that.
And that I guess that's,
But
maybe if they keep remanding over and over and over again, at some point you can say it's an abuse of discretion, maybe, although I've never seen that either. But if they have the discretion to remand for any reason, how do we, as the appeals court, say it was improper to remand?
So my response to that, Justice D'Angelo, is that while they have certainly the discretion to remand, the remand has to be for an appropriate reason. And in this case, I don't believe, or the board does not believe, that the remand was appropriate because the issue regarding the cyst was either traumatic or incidental, and there's no further opinion that needs to be flushed out on that issue. And as it turns out, the second medical panel also said it was incidental. But with the remand, Your Honors, and I want to point this out because as Justice Tan said appropriately, this is a tortured case that Mr. Downey and I have been involved with for almost 20 years now. The remand was focused not on the lower back injury, was focused on the cyst, that the doctors didn't explain it well. But then when we get to the second panel, Your Honor.
They switch. and then
Right,
they-
it's a new panel because the old panel wasn't available. So they didn't find the first panel was improper, they just wanted further clarification from the first panel. So now we have a second panel. The second panel says, well, the lower back injury did cause the permanent incapacity, but the cyst was incidental. Now, if the remand was only on the cyst being incidental, the medical panel said it's incidental. That case should have been over. But again, so we denied it again at the board level with the second medical panel. We go to Dallar a second time. The Dallar magistrate finds that the medical panel was proper, didn't address any of the issues we raised. As you can see through the record, there's a mountain of evidence, both for and against, and it certainly is incumbent upon the magistrate to weigh that evidence and discuss it, but they just found the panel's opinion was proper. They basically, in our view, ignored the limited scope of the remand, so then we're back up to CRAB again for the second time, and that's Pellen too. What CRAB does the second time is it agrees with the board that the lower back injury did not cause the permanent impairment, and they articulate very good reasons. This is the only aspect of this case I agree with CRAB. They articulated all the reasons why the lower back injury didn't cause the permanent incapacity, but then CRAB goes completely off the reservation and says the thoracic cyst, which the medical panel said was not disabling and was incidental, CRAB finds that that decision, that injury or that condition resulted in a permanent impairment and awards accidental disability retirement. So
I mean, ultimately, though, right, isn't the standard of review of a CRAB decision pretty deferential, right? We can, if it's legally erroneous or not supported by substantial evidence, which you acknowledge, I appreciate in your
Exactly.
brief, is a fairly low bar.
It is, Your Honor, but that's the problem we have with the Superior Court's first decision to remand, again, interlocutory, that we couldn't appeal. And again, Justice D'Angelo, they have the discretion to remand, but what the Superior Court found, and I realize it's the CRAB decision that's before you.
You're talking about the first.
The first Superior Court, with the first Superior Court, Justice Hodge, what he found was that CRAB was wrong to focus on the cyst because the medical panel didn't certify the application based on that. But then he remanded it back to have CRAB decide what it already decided on the lower back injury. CRAB gave a very well-articulated rationale for finding that the lower back injury did not cause the permanent impairment. And as you just said, Justice Tan, the Superior Court is not supposed to substitute its judgment, and CRAB did.
Except whenever you disagree, agree with them, right?
Well, no, I mean, I can certainly challenge their decision, but in terms of the court giving deference to that decision, what Justice Hodge did was, on the lower back injury, he remanded it back for CRAB to consider whether the lower back injury caused the permanent lower back impairment, but they already did that. And there was no reason for him to remand it back on an issue that they already decided and was well articulated and was supported by the evidence. The Robinson case that I cited in my brief is such that it's CRAB's duty to weigh the conflicting evidence, and it's not the court's duty to choose between the conflicting evidence. It's only whether there's sufficient evidence, and as you said, Justice Tan, a very low bar, sufficient evidence to sustain that finding. And there was ample evidence to sustain the finding that Mr. Pellen's back injury did not result in a permanent back impairment. But instead of affirming what the Superior Court should have done was it should have found CRAB's decision was erroneous on the arachnoid cyst, but affirmed it on the lower back, and then my brother could have taken the appeal and would have been here in that posture. Instead, he remands it back to CRAB. So now we're back at CRAB for the third time. CRAB, for perhaps just throwing up their collective hands, decides we're going to rely on the magistrate. And I'm not sure which magistrate they're referring to, because when you look at the second Dalla decision, that magistrate, the Superior Court was very critical of that decision because all that decision did was give conclusions, not rationale for the findings. And in this case, finally, the third time, CRAB says, well, we agree with the magistrate, they've made their case. Well, how did that happen? How did they go from saying there's all this evidence to support that Mr. Pellen's injury didn't cause his permanent impairment, and then without any explanation whatsoever, they completely reverse themselves and say, no, we will look at what the magistrate said below without specifying whether it was the first magistrate who found the lower back injury didn't cause the impairment or the second magistrate who found that it did but didn't explain herself. So now CRAB has just reversed itself and said he's entitled to an accidental disability. We appealed that. We end up at the Superior Court for the third time, or second time, excuse me, on the third case, and Superior Court affirms that decision. So you're absolutely correct, Justice Tan. This is a tortured case. I've been doing this for 30-plus years. I've never seen a case go on this long, have this many hearings and remands, but there were so many errors along the way. You know, and this is obviously, unfortunately, Mr. Pellen has passed in this process, and, you know, that's unfortunate. But when we look at the financial burden that will be placed back on my client, Your Honor, and all of the mistakes in this case, that we believe the evidence was sufficient for you to find that there was error in the first CRAB remand, error in the first Superior Court remand, and that the evidence in this case does not support a finding that Mr. Pellen's September 25th, 2006 back injury caused a permanent impairment to his lower back. That's what CRAB found in Pellen 2. That decision was clearly supported by substantial evidence and not erroneous as a matter of law. CRAB definitely committed error of law, and the decision was not based on substantial evidence when it came to the cyst, and no one disagrees with that. I think we're all in agreement. 6 doctors have come to the same conclusion that the cyst was incidental and not causally related to the injury. So I see my time is up.
Thank you.
The court doesn't have any questions. I'll rest on my brief.
Thank you very much. Mr. Downey.
Good morning, members of the panel. May it please the court. I'm Thomas Downey, counsel for Michael Pellen, the appellee, who is now deceased. He passed away on June 7th, 2024. His son, Jonathan Pellen, has been substituted as Mr. Pellen's personal representative. I apologize for my voice today. I thought I was over an allergy problem 2 days ago, and it's come back this morning, so I do apologize. Mr. Pellen, as was mentioned, filed his application for accidental disability retirement in 2007. The application has now been reviewed favorably by the medical panel, which was his second, the Division of Administrative Law Appeals, DALA, and CRAB, as well as the Massachusetts Superior Court. The first question that was discussed at CRAB Air in 2013 when it remanded for a new medical panel, and I should say, to clarify, the CRAB did not request a new medical panel. It sent the case back to the retirement board with instructions for the first medical panel to answer pertinent questions that the panel had failed to address.
They were not available, right? So they had to reconvene a second panel.
Yep, so it wasn't seeking a whole new, to start all over again. Unfortunately, they were not available, and that happens fairly frequently in the system. And it had to do with Mr. Pellen's thoracic, pain in his thoracic spine. And the only reference by that first medical panel was that it was an incidental finding. So it would be frustrating for an employee or an applicant or a member to just have the justification be, in terms of causal connection, that's an incidental finding with no explanation. A medical panel certificate is legally insufficient if it fails to justify or support its opinions, including its opinion as to causation. And that's the Noon case. The proper course is to resubmit the matter to the medical panel so that the panel can apply the correct standard. The second panel was only convened when it was determined that the panel number 1 was unavailable. But I should just say that when CRAB dealt with the case, it went to great lengths to make sure it was not substituting its opinion for the medical panels. We expressed no opinion on the ultimate question of whether Pellen has proven by a preponderance of the evidence that his thoracic cyst spinal injury and resulting disability were approximately caused by his 2006 injury. I should note, though, that the appellee believes that medical panel number 1 was flawed for another reason, as was discussed, and that was when he initially applied for accidental disability retirement with the board, the Franklin County Retirement Board. He was told that his application was deficient, that the physician's portion of the application submitted by his primary care doctor, Dr. Anderson, was insufficient, and they asked for additional medical information. Mr. Pellen was examined by Dr. Corsetti, who was a practicing orthopedic surgeon, and that report was submitted along with the physician's form to solve or to address that insufficiency as directed by the board. At that point, the application was deemed complete. But when one looks at the manifest, the list of exhibits that were sent to medical panel number 1, Dr. Corsetti's report is not listed on that. The report itself recounts the medical exhibits that in the narrative summary by the 3-doctor medical panel. It reviews the medical information that it reviewed as part of its examination. Dr. Corsetti's report is not listed there. So the board was the one that said his application was insufficient without Corsetti's application, without his report, and then sends the matter forward, but did not, it appears to a reasonable person that Dr. Corsetti's report never made it to the first medical panel. That was injurious to Mr. Pellen's application. In the Coet case in 1996, the case was remanded because a member of the medical panel failed to review pertinent medical records. I think that may have been a job description to see if someone could do their job. But the failure of that report really is a significant thing. I should note that the regulation 840 CMR 10A requires the board to submit all medical data and information in the member's file, including physician statements, through PARAC to the medical panel.
Can you address your opposing counsel's argument about the reliance on the 3 medical journal articles? And
yes, and I do, you know.
Was it error?
I think it was error to suggest that was the ultimate conclusion, but the CRAB did not do that. It remanded it, and I think it is material that's extraneous to the case, and I understand that, but I think given what they had to deal with, and then that decision recounted that there was no evidence in the medical records of infection or some underlying disease, so it was sort of a mystery as to what caused the cyst. And just procedurally, when Mr. Pellen filed his accident report within 24 hours of the incident, he put down he injured his lower back as well as his thoracic, his mid-back. When he saw a chiropractor the next day, Dr. Evans at Strength for Life Fitness, Dr. Evans said there was a low back injury, a thoracic injury as well. Every treating doctor that Mr. Pellen saw, Dr. Evans, his primary care Dr. Anderson, Dr. McKay, who did the surgery on his thoracic spine for the arachnoid cyst, and as well as Dr. Corsetti. So all 4 treaters found that he had both a low back injury as well as a thoracic injury. But I think...
Well, 2 of the doctors, Dr.
Kawiak.
Thank you.
Yes.
And Dr. Silver, who saw him shortly after the injury, noted, right, that they thought he was exaggerating symptoms and that he would be able to return to work with some weight restrictions.
Yes. And I should just point out that Dr. Kawiak, Dr. Silver, Dr. Levine, and Dr. Wenicky are, I should say Dr. Wenicky is an impartial physician. So he is a doctor that examines people at the Department of Industrial Accidents at the request of the department. The other 3, Drs. Kawiak, Levine, and Silver, are independent medical examining doctors. They are contracted by the workers' comp insurer to examine Mr. Pellen following his work injury. I don't want to exaggerate and say it's an adversarial relationship, but it is not a doctor-patient relationship. It is a one-time exam in each occasion, and they have contracted with the insurer. And but I think what sort of compromises their opinions in my regard is that they were not aware that Mr. Pellen had an arachnoid cyst compressing his spinal column in his thoracic spine. So when they say symptom magnification or his responses are exaggerated, he was in a significant amount of pain. And that's not my thoughts. Those are the thoughts of Dr. McKay. In her report, she pointed out that his responses were sort of normal or understandable given that he had a cyst that was compressing his thoracic spinal cord. So I think the fact finder has to weigh, which are more persuasive, the treatment providers that saw him on a regular basis over a period of time, one that did surgery in Dr. K's case, and then the other 4 doctors who saw Mr. Pellen on one occasion and came to their conclusions after that one exam.
Counsel, can we go back to the remand for a second? You agree that it was the first remand, that it was sent back to answer very specific, pertinent questions. What came back was certainly more than that. So is that an error that they did that as opposed to just answering the questions they started over? I know it's a new panel, but
Yes, Your Honor.
they were that's not what it was remanded for.
Yes, Your Honor, and I found that to be, a challenging question from our perspective or point, but, in reading the regulation, it talks about that when a second medical panel is convened, then the first medical panel, in terms of evidence, it's not to be sent to the second medical panel. And so it's almost, and the regulations also talk about that it's as though that first exam never happened. And I think it's intentionally designed that way. So I could give you the case site, Your Honor. But so I think it's a system that we're living with. But when you go back for a second panel, if it's with a different three-person panel, the first panel does not see the light of day with the second panel. It's not to be referred to, and that's not only it's not only in the regulations, but it's also case law. I think the case is LaRue, and it's the regulations make it clear that an instance such as this in which a new medical panel is requested and granted by PERIC, any earlier panel's findings are irrelevant. David LaRue, 2010, CMR 10, Section 10.8.7 states expressly, a new medical panel shall not be provided with copies of the certificates and narratives of the medical panels which previously examined the member. So I think it's sort of knocked out on both points. And I've never seen, I should say that after the second medical panel was done, there were questions sent by the board asking for clarification as to some of their conclusions as well. So there was then there was an addendum from the second medical panel. So, but it, so I think it was mentioned when Superior Court is dealing with things, I think that they dealt with the case in sort of the least intrusive way that they could, and that was to send it back.
So, right, can you address that? Can you address the remand in Pellen 2 that the opposing counsel said was improper?
Yes, and so judicial review of a CRAB decision under Chapter 30, Section 14 is narrow, the Retirement Board versus a Board of Salem. And the Superior Court commented it typically defers to CRAB's expertise and accords great weight to its interpretation and application of the statutory issues it is charged with administering. I think the court ultimately found that CRAB 2022 rejected the medical panel's unanimous conclusions and thereby waded into medical issues. It sort of exceeded its bounds and waded into medical issues which are beyond the knowledge of CRAB, and that follows the Malden Retirement Board case.
So you don't concede that it was improper, the remand?
I'm sorry?
You're not conceding that it was improper remand by the Superior Court?
No, I'm not conceding that. Yeah. No. And I think because they remanded with instructions, I think there was ample opportunity to just clarify its decision. I think one of the arguments in the brief was that the case, Pellen's application did not have or pass a substantial evidence case. And, we may have set a record with 1,300 pages in the evidence, and it's not all relative to medical treatment. But I think what's important to look at, I guess, from Mr. Pellen's perspective is right from the very first moment, if we take an overview of the entire case history, that he filed his accident report within 24 hours, saw a doctor within 24 hours, saw another doctor within 48, and it's always been consistent. And I think that's why the second medical panel found what it did, that it read all the medical records, including accident reports. And I know when you have as many doctors as been involved in this case, not everyone is going to agree, but there's certainly, he has met his burden in terms of proving with a preponderance of the evidence that he should be awarded accidental disability retirement benefits. Happy to take any questions from the panel.
Seeing none, thank you. Thank you both.
Okay.
Take
Thank you very much.
The next case is 25P Rodriguez versus Rodriguez. Mr. Derlin.
Your Honors, Sandy Derlin, Warner, Federico, and Ryan on behalf of the appellant. Good morning. Good morning. I know you're familiar with the paperwork in my brief, and I won't belabor the point. I just have a few brief remarks subject to any questions the panel may have. My brief addressed two discrete issues, one of which is much simpler than the other, and the simpler issue is at the end, and that pertains to an allocation of costs relating to religious instruction, CCD, Sunday school, and whatnot. And I won't address that unless the panel has any questions.
I do, actually. You said that your client did not have notice, correct, of this expense?
Yes.
So in Record Appendix 2, page 105, line E, there's weekly expenses, and this is all, I think, uncontested, right? And it says CCD, and then next to that amount, $1.44. So is that not?
Well, there was no, I mean, at trial, there was no testimony.
But this was part of the record, correct?
It is part of the record, but I think merely listing an issue per se without exploring it in the underlying proceeding, I think, constitutes waiver. And so from my perspective, my client was not prepared, did not expect that issue to be sort of rolled into the judgment, which was the language of which was taken verbatim from the proposals of the wife's attorney.
It's not covered by child support?
The CCD payment? Well, it could be, but in this case, the judge specifically made provisions for things like soccer and dance classes and whatnot.
I can understand why you didn't want to talk about this, but are we talking about 72 cents a week?
No, that's why, I mean,
How much is it?
there was no evidence about it. I mean, that's my point at the trial. So, you know, one could say, well, what's the harm, you know, if your children go to
Well, I think Ms. Rodriguez makes a good point. Certainly he was on notice that they raised their children Catholic, and certainly he's on notice that he's Catholic, and they've been sending them to CCD. I don't understand why this would be a big surprise.
It's not that it was a surprise. In other words, I don't think he was blindsided, to use that phrase, but there was no evidence about that at trial. I mean, we can all sort of assume, or there may have been some, you know, suggestion that they're Catholic and they're raising their children Catholic and so forth. But that wasn't part of the trial record.
But if distribution is not required, mathematical certainty is not required.
True.
Why are we arguing about something so unbelievably de minimis?
Your Honor, I'm not disagreeing with you in the larger scale of the issues before the court, which is why I think I addressed it in 2 pages in my brief. I'm not throwing it away. I'm not conceding it for purposes of today's argument. All I'm saying is, in the record, it was not, in my view, properly perfected, and therefore, the judge effectively made an assumption based on the proposals from the wife's attorney, and that is my quarrel with it. Would I have taken the appeal on that issue? No, I wouldn't have.
And yet here we are.
My client wouldn't have either. So the larger issue is the division of the appreciation in the marital home. And everything else is not challenged by my client insofar as the equitable distribution is concerned. My client doesn't even challenge the metric in the way that the judge allocated that appreciation by crediting the wife with certain expenses. His challenge, as I pointed out, rests on how he balanced other credits that my client sought against credits which the wife sought, meaning his credit of overpayment of child support versus her credit of paying for ancillary uninsured expenses and extracurricular activities. The judge effectively divided the wife's share of appreciation in half for purposes of the credit, but in doing so, he again ignored evidence as to other credits which were part and parcel of my client's claim and defense against sharing that appreciation. First of all, the judge was presented with evidence and made findings on the underreporting of income by the wife. But those findings are both incomplete and incorrect when the matter came before the judge. When you compare the disclosures on her financial statement with her tax returns and W-2s, it's evident that there was an underreporting of a grander scale than I think the judge believed, or the judge, he didn't make a specific finding, but he seemed to link that overpayment as a wash against the other expenses that the wife paid. And throughout the period of the litigation, that underreporting of income was not insignificant and would have made a material impact on the child support, which again is what he sought, but which the judge did not make specific findings about.
Help me out factually. So the judge recognized husband's overpayment of child support and then offset that with not requiring him to pay half of the medical costs.
Correct. And in my view, that's apples and oranges, because the amount of the overpayment was between $50,000 and $60,000 of child support, as I calculated, and as the husband's trial counsel proposed. The amount of the expenses were roughly $11,000, so you're really comparing apples and oranges. And the failure—
Is that based on competing testimony?
I don't think so, because again, the wife's income is reflected on her W-2 when compared to her financial statement, and you can see a delta there. And the tax information was much higher, and therefore my client was paying close to $500 a week in child support based on underreported income. And when you factor all that in, the amount of both underreported income on an annual basis, when you consider the fact that it's formulaic insofar as child support is concerned, the child support would have been substantially lower over time. And that's what the judge simply washed away without making any findings, acknowledging it, but not making findings. And that's where I think he erred, because that was the crux of my client's claims against the division of the appreciation. And so the failure to make findings there is really what is problematic. And without those findings, you know, it's hard to discern whether it was an abuse of discretion, whether it was rational, but whether it was reasonable. On the evidence, it does not appear to be so. And that is the crux of really this appeal. And without belaboring the point, I'll take any questions, otherwise I'll rely on my brief.
Seeing none, thank you, Mr. Dillon. Ms. Rodriguez.
Hi. Oh, sorry. Thank you so much for letting me do this and letting me talk to you all. So good morning. Oops, sorry. I am Stephanie Pettee. I am representing myself. So I guess to start, I would say that, as I'm sure you're all aware, there was a case, I'm so sorry, let me just, with the Massachusetts Supreme Judicial Court held in Jeevanandam versus Baratha, Massachusetts, does not provide reimbursement for overpayment of child support. This is crystal clear, particularly due to the fact that Mr. Rodriguez mentions nowhere in his appeal that this money, that this reimbursement, which he refers to as a credit, but really it's a reimbursement on his end, is going to go towards the care and maintenance of our children, which is a requirement. Nowhere in this appeal does he discuss our children whatsoever and how this money will benefit them. Additionally, if we're going to go, based on what Attorney Derlin said, it seems pretty cut and dry that, Mr. Rodriguez way overpaid based on the calculations. But what these calculations are, if you see on page 28 of his brief, the calculations are based on my W-2 earnings, which are my actual earnings. However, the calculations are based on Mr. Rodriguez's base income with his car allowance. That's not his W-2 earnings. Actually, in 2021, which was when this kind of started, half a decade ago, Mr. Rodriguez had a base pay of just over $90,000. However, on page 14 of Attorney Derlin's brief, you will see that his actual earnings were over $294,000. So, and again, on page 26 of his brief, he states that when calculating support, income is defined as gross income from whatever source. I would say that commissions, particularly hundreds of thousands of dollars of commissions, should be put towards the calculation of child support. And I understand that Mr. Rodriguez disagrees with this, but the state does not disagree with this. If we're going to consider all of my income, we should be considering all of Mr. Rodriguez's income. Additionally, I'm just going to talk plainly. I am not good at financial forms and stuff like that. It's not my strong suit. It was. I'm sorry. I'm trying not to get emotional. It was not malicious. If anything, the reason why my income has grown so much is because Mr. Rodriguez and I have two daughters. I have an older daughter from another relationship, and I find it my personal responsibility to work to the best of my ability to make as much money as I can, and I wasn't trying to hide it. In January of 2022, I went, I'm so sorry.
You take your time.
I went from working 2 days per week, because when I was married, I was working 2 days per week so that I could raise our children. And I was able, incredibly blessed, that I was given an opportunity to work my dream job at MGH. Thank you. Full-time, which is where I work now. So in January of 2022, when I filled out my financial statement, I had no idea that months later I was going to wind up with this full-time job. So obviously, if we're comparing my income on my financial statement from January of 2022, and then we're going to compare it to my W-2 in December of 2022, there's going to be a large discrepancy. There is, and it wasn't malintent. It wasn't anything. I just would pick up shifts per diem prior to my full-time job. I would, work those shifts. For example, someone went on a maternity leave at a different MGH location, and they said, does anybody want to pick up shifts? I'm picking up shifts. I have no money. I did not have access to the HELOC that Mr. Rodriguez had, even though it was a marital asset. He had only received permission from the court for $30,500 to take out of that HELOC. But if you look at the information from our case, from the trial, Mr. Rodriguez spent over $176,000 in monies from that HELOC without permission from the court, aside from the $30,500, which were advancements towards the marital estate towards me. I am not arguing that, you know, I don't think that I perfectly filled things out. Again, it was not malicious. I have no intention of, you know, if he were to take me back right now, my financial statements got better and better throughout the years because I got, you know, as you can see, there was lots of litigation, and unfortunately I had to get better at that. So I did. I was working as my own paralegal, even though I had an attorney, because again, I did not have access to the funds of the HELOC that Mr. Rodriguez had to have, you know, paralegals and all these people working on it, which is why I'm standing before you, pro se.
Ms. Rodriguez, can I?
Of course, yes. I'm sorry. I'm probably talking 100 miles an hour.
Because the other side brought up this expense for the religious education,
Yes,
the CCD.
yeah.
And so I know you mentioned in your brief that there were, you know, and we mentioned the financial statement, but also you mentioned that they were reflected in bank statements, right? Do you know if those bank statements are somewhere in any of the information that got sent to the appeals court?
I don't think they are. However, I will say that this was mentioned in the GAL report because this was an ongoing issue for years. You know, I had mentioned to the GAL that Mr. Rodriguez no longer wanted the children, and I can provide you with the information on what page it is in the GAL report. Sorry.
Right, or if there's anywhere else in the papers that we have that might.
Just in my financial statements, and of course, you know, I did not know if I could put emails into, you know, it was.
That's okay.
So it was in emails multiple times. He wanted them to play soccer and no longer wanted them to attend church services and no longer wanted them to go to CCD, but.
How much is the weekly cost of the CCD?
It's something like $1.50 or something like that. I mean, the total cost for all three of my children, which obviously Mr. Rodriguez, I had kind of parceled out the amount for the two girls and then split that in half. So it was $170 for the year for all three of the children. So obviously it was like under $60 for Mr. Rodriguez to pay. If it's going to make this go away, I don't mind paying it. I just want them to be able to go. That's all. Okay. And to be honest with you, I didn't really realize, and I don't even know if my attorney realized that there would have to be this advance notice since we baptize our children together. And Mr. Rodriguez attended CCD services himself. He's aware that these classes are required as a part of our religion to, you know, get the sacraments so that you can go to heaven, right? So that's, you know, just part of what we're doing. So it was honestly confusing to me and hard for me to even address that in the appeal because I'm really not even sure what to say. It's not a secret. I feel like, okay. Oh, additionally, I just wanted to add that on January 26th of 2023, Judge Dunn had made an order for Mr. Rodriguez to, we both swore under oath that we would agree with the GAL findings. You'll find that in the paperwork that on January 26, 2023, we both agreed whatever the GAL said, which we already knew because it came out in November of 2022. She thought that we should have 50-50 custody, that we would agree to this so that we wouldn't have a trial. So because of that, Judge Dunn reduced Mr. Rodriguez's child support obligations to the 50-50 custody calculation, despite the fact that we had not come up with a settlement yet. I agreed to that. I thought that was fair. Unfortunately, Mr. Rodriguez would go on to refuse to settle the case and refuse to agree to the GAL recommendations for an additional 16 months. So then he was paying 50-50 child support on a custody schedule in which I had full custody of the children. So that's over $27,000 that Mr. Rodriguez underpaid. Mr. Rodriguez also, on all of his financial statements, it's easy to say that he was telling the truth and he was, I was the one underreporting when Mr. Rodriguez never puts a total weekly gross amount outside of his base income. He would put in the explanatory note that, well, I make commission and it's been this much this month and it's been that much this month. And, again, based on Attorney Derlin's own calculations, he made $294,000 plus dollars in 2021. However, the calculations were based on $249,000. So just 1 year, he underpaid by $50,000. And again, I really just wanted this to end. I want it to end now. I'm sick of, coming here. I mean, you guys are great, but You know, you're lovely.
I don't blame you for
you're
not
lovely.
wanting to be in front of us either.
I can't do this. I'm so sorry.
It's all right. Tana and I are great. We don't know about
Don't take it
D'Angelo.
personally. But yeah, I mean, it's exhausting. And you know, also, because I still have a green light, I'm going to keep going. I'm sorry. Judge Dunn had, when he gave he ordered the $13,500 in, it's in there, I'm so sorry. Okay, that's in volume 1, page 34, for attorney fees that they could, but not necessarily should, come out of the marital estate that I would be giving, my half of the marital estate. So given just what has gone on, how much money I had to spend on attorney fees, the fact that I'm standing here right now, and I left Mr. Rodriguez almost 6 years ago, I personally feel, based on case, I'm gonna find it, Kittredge versus Kittredge, conduct during proceedings can have an effect on distribution of the marital asset. I do believe that that $13,500 should not have been taken out of my half of the marital estate. Mr. Rodriguez or a party from his family or someone filed a 51A on me in December of 2022, completely unfounded, completely fabricated information that never even got investigated because it was ridiculous. Mr. Rodriguez he stole over 40 nude photographs of me from my iCloud account and gave them to the GAL. He blew them up in 8x10 photographs, and she left it out as the first piece of evidence, you know, and he never had to face any consequences for that. And all I wanted to do was just leave him. I just want to start over. I just want to like focus on our children. If I have to pay him back almost $70,000 in these erroneous fabricated numbers, I'm going to lose our home that I bought. Finally, I bought my own home. I cashed out my 401k because I had to spend all of the money that I received from our divorce on legal fees. I cashed out my 401k and I bought the condo that our children have been living in for the last 4.5 years. And, you know, I don't want to have to look at them and tell them that we can't live there anymore. Okay, I'm sorry. I think I'm done. Do you have any questions? I'm sorry.
Seeing none, no. Thank you.
I'm a basket case. I could never be an attorney.
You did fine. Thank you for your collegiality, Mr. Drilling. We'll take it under advisement.
Okay,
Thank you.
Thanks.
Our last case, we get to hear on Zoom. So with that, I'd like to thank our court officers, our court staff, our clerk's office, my colleagues, our law clerks, our excellent timekeeper, and we will be in recess. Thank you.